afternoon, everyone. I'm Helen McIntosh, and I'm the president of the South East London Chamber of Commerce. Now, wearing my hat as the president of the South East London Chamber of Commerce, as many of you know, we cover the boroughs of Royal Greenwich, Lewisham, Bromley and Bexley, and very shortly we'll be embracing Croydon. We're very excited about this. There is a reason that we're embracing Croydon, because we're affiliated to the London Chamber of Commerce and Industry, and they're very keen for everyone to work in localism. So that's why Croydon is coming under our umbrella. So that's my little spiel about our geographical area. I'm delighted that this is the first property group event that the Chamber is holding. And I would like to thank my co-director, Yildiz Betez, who's one of our speakers today. This is her baby. And I think we're going to see a lot more of these events in the forthcoming months. Now, we are delighted to have a sponsor. This is all very businesslike. We're lovely to have our sponsor today, Blue Light Group. And I'd like to introduce Luke Bryce. Luke, over to you.
Thank you very much, Helen. So yes, as Helen said, my name is Luke Bryce. I'm one of the directors at the Blue Light Group, but it's my pleasure to be the main sponsor for today's first South East London Chamber Property Group. So thank you very much for having me. I just wanted to use this little bit of time to introduce you all to our company, which is called the Blue Light Group. Originally formed in May 2018, Blue Light Group actually began as Blue Line Security. My business partner and I are both former Metropolitan Police officers from Croydon, and we sought to become the security company that was a little bit different to all the rest, offering security solutions in a professional capacity as opposed to just intimidation. We began by offering guarding, concierge, door supervision and patrols primarily in London and the South East, which has led to clients in commercial offices, construction sites, shopping centres, and even a billionaire on the South Coast, which is a little interesting. I like his car collection. Fast forward a couple of years, we've just completed a full restructure and rebrand, whereby the group now offers a cleaning and maintenance arm, again aimed primarily at commercial offices, shopping centres and construction sites. Now offering that one-stop shop for commercial clients, our current clients are already feeling the benefits. Hapag Lloyd Shipping, their UK head office, is one of our security clients and have been one of our first clients for full service facilities management. Given that our guards control the access to their site at various times of day, it made sense when they had a maintenance issue to delegate the entire process to us, as we were able to easily coordinate the maintenance team to work with the guarding team, so there were no cross wires. One email from the client was all it took for us to take the problem out of his hands, rather than middlemaning and coordinating two different groups of people. Some examples of our current client base include household names such as Sony, Hapag Lloyd Shipping, McLaren Construction, Wilmot Dixon Construction, Box Park in Croydon, Knight Frank, Wandsworth Borough Council, Travelodge, and the Westgrove Group, where we support their functions in shopping centres nationally with their clients CBRE and Savills. And funny enough, I've just got off the phone about an hour ago with them. They're tendering for a site in Greenwich, which you mentioned just now, Helen, so be even closer to home. But it's not just the behemoth internationals we work for, it's just these are the only ones most people would recognise. It's the relatively impressive list of clients that I find best to fully describe the success that we've had since incorporating that short time ago. Our passion is property and the protection and presentation of it, with the client's needs always at the core of our offering. I've got our 21 brochure here in digital format for anyone that wants to take a look at the various services we offer. And I think I'm the only person here talking today who hasn't got my email, home phone and inside leg measurement going to be available on the slides. So if anyone needs anything, please do give me a shout and I'll pop my contact details into the chat box. And for now, I'll hand back over to Helen to continue the running order of the day. Thanks very much.
Thank you very much, Luke. And you must be pleased that we're going into Croydon.
Yeah, it brings you a bit closer.
With all your work there, yes.
Exactly.
And we'll see you in Greenwich. Excellent. Indeed. Thank you very much for that. And thank you for being with us today.
Pleasure.
Right. We have, as you will have seen on the earlier video, we have a trio of partners of Thackeray Williams. And the first one to kick off will be Andrew Raby, who's the senior partner. And Andrew's expertise is residential property, rent arrears, landlord and tenant update. So Andrew, with your lovely new corporate logo, over to you.
Thank you very much, Helen, and good afternoon, everyone. It's a pleasure to be able to talk to you, and I hope you're going to find the session interesting and useful. My name's Andrew Raby. I am the Senior Partner of Hacker Williams LLP. We are a full-service law firm that was born out of a merger, a successful merger, we like to say, in 2004. We're based in Bromley, and originally we were in Bromley with 1 or 2 satellite offices, but we've expanded, we've been growing. We're now, we opened a Sevenoaks office in 2018. If you can hold the slide there, Mike, that'd be great. Last year, we opened an office in the City of London in 2020, a brave move during that year, but we've done that. And despite the turbulent times, we have also been growing as a firm and recruiting. We've probably recruited half a dozen people, I would say, since the autumn. So today's star-studded lineup includes myself and also 2 of my partners, Yildiz Betez, who is head of our commercial property group, and also David Hacker, who is head of the litigation team and works with me in litigation. I mentioned the successful merger a moment ago in 2004. All 3 of us were part of that merger, 2 of us from one firm, 1 from the other. And as we're still together as partners 16 years on, I guess that is perhaps one measure of our success. If you can move on to the next slide, Mike, that'd be great. Thank you. So a theme of today's talks is the impact of the coronavirus on landlord and tenant, both commercial and residential. David will talk about commercial property from the contentious or litigation point of view. Yildiz, on the other hand, her talk will be more from the non-contentious side. My task is to talk about residential landlord and tenant and what can be done about rent arrears if you face that as a landlord in the current climate. So without further ado, let's take the first bite into the meat of our presentation today. If I could have the next slide, Mike. Thank you. I mentioned I'm senior partner. I also head up our Sevenoaks office, and I'm also on the board on the Sevenoaks Chamber of Commerce. But far more relevant for today and more important is, as part of the litigation team, I specialise in residential landlord and tenant, and in particular disputes concerning properties let on assured short hold tenancies. Most of you may well know, I don't know, that assured short hold tenancies, or ASTs as they tend to be known, are the most common form of tenancy used in the residential sector. If you own a property as an investment which you let out, or if you're a tenant renting a property, you're almost certainly using an AST. And in terms of an update, we're really talking about the impact of COVID and the emergency legislation that was brought in by the government in March last year, primarily to protect tenants, known as the Coronavirus Act 2020. And I think it's fair to say that as landlord and tenant lawyers, we've had tremendous fun in the last 10 months trying to keep up with changes brought in by the government. The Act effectively allows the government to pass regulations and make changes quite quickly. For example, they can change notice periods, which is something I'll talk about quite a bit in this talk. To put that in context, I started thinking about this talk in the first week or so of January, and frankly, there have been several changes since I started thinking about it. So to be perfectly candid with you, what I'm going to say is up to date as at today, I believe, but it may well change quite quickly in the next weeks and months. So a very quick history lesson, if you like. As at March 2020, at the beginning of March last year, the most common notices served by most landlords on a residential tenant would be either a Section 21 notice running for 2 months or a Section 8 notice, typically relying on rent arrears, which would be typically a 14-day, 2-week notice. But as at the 27th of March 2020, when the Act came into force, things changed. All current possession proceedings at that time were stayed for 90 days, in effect frozen in the court system. And both Section 8 and Section 21 notices had to be served with a notice period of 3 months. So quite an increase for Section 8 and up by 50% for Section 21. In June 2020, the stay was extended. On the 23rd of August, the stay was extended again through to the 20th of September, at which point the stay came to an end. So it's a bit of a case of pressing play again if you had any claims running and you wanted to pursue your claim. However, there was then a further problem because as particularly London and the South East entered tier 3 in the autumn, the government made it clear to bailiffs that they mustn't evict any tenants through warrants of execution. And in fact, that ban on evictions was extended in the winter over the Christmas period, so that from 11th December through to 11th January, all warrants were suspended and couldn't be executed. And indeed, true to form, that particular extension ending on the 11th of January has just been extended again to the 21st of February. And it's fair to say some of these extensions have come in very late in the day. One of them in last year was announced by Twitter, of all things, last minute, I think the evening before it was coming to an end. And even the recent extension was only announced, I think, lunchtime the day before on the 10th. So where are we now in terms of notice periods? The simple answer is we're now up to 6 months for both notices. Section 21 is a 6-month notice. Section 8, in most cases, is also a 6-month notice, but there is some hope for landlords who are facing a problem with rent arrears with a tenant, in that if you have 6 months worth of rent arrears, then ground 8 allows you to serve a 4-week notice. So that's some improvement, but you need to be wary if you are serving a notice, because there are different periods of different notices. Next slide, please, Mike, if you will. So I guess a key question is, can a landlord actually evict a tenant at present time? The answer to that is yes, but it will take longer. You've got additional steps in the procedure. There's going to be delays in court. Notice periods, as we've said, are longer, and also currently bailiffs can't execute warrants if you have a possession order at the moment. So what has really changed? I think there's a change in emphasis and, if you like, what people are saying to landlords, because the government from the start of this in March last year has basically encouraged all landlords to not evict a tenant if at all possible. But a lot of the changes are really practical. In the court process, if you've got a claim that already exists and was stayed, you have to serve something called a reactivation notice to start it again. That's a new step. There are now review dates, so an additional hearing date, which again is an additional step in the court process, again delaying things a little because you're not going to get a hearing date until that date's been dealt with. Similarly, if you're pursuing arrears, then the previous timetable provided that there would be a hearing date within 8 weeks of the claim being issued. Sadly, that's now gone, so there's no fixed time periods for hearing dates. There's added emphasis on attempting to communicate with your tenant before the process starts, and possibly even go to mediation. So what do you do if you are a landlord and you have this problem? You have a tenant who's causing problems, or a tenant who simply is falling into arrears. Well, the word that you're probably going to hear more than once during the talks today is it's all about communication. You need to speak to your tenant. You need to try and communicate with them if you can. Find out if the problem is COVID related, because you'll be expected by the courts to deal with that. And also ask them, what have they done themselves to help themselves, rather. So, for example, one of our larger clients who have a lot of property in South East London, and a good amount of that let on ASTs, they've actually spoken to pretty much all their tenants insofar as they can. They've discussed their circumstances with them. They've particularly asked them what they have done themselves about helping themselves in this crisis. Could they apply for more benefit, for example, if that's appropriate, or even apply for benefit if they've been made redundant. And the options include possibly deferring rent, or either in part or in whole, signposting tenants to other sources of help, such as Citizens Advice Bureau, shelter, local authority, particularly somewhere else where they can get advice on finances and rent arrears. But also crucially, and this applies perhaps to a lot of private landlords, perhaps only have 1 or 2 properties, can they reach an agreement with the tenant whereby the tenant agrees to surrender the property, possibly with any arrears being waived, because it may not be cost effective or time effective to pursue them, or indeed even paying the tenant something to go, what you might refer to euphemistically as removal expenses. I suppose the other question at the moment is, what has not changed? In my view, something that hasn't changed is any landlord at any time, if they face a problem with a tenant, whatever it is, whatever the nature of it is, they need to act quickly. Don't sit on your hands. Contact the tenant, find out what the problem is, try and address it if you can. It typically won't get better by doing nothing. Communication with the tenant, as I say, is key. Another of a client of ours that has a lot of property in South East London and North Kent, actually, with a lot of ASTs. They're extremely good at communicating with their tenants, always have been. They tend to spot problems before they arise because they get to know their tenants. And I would say this is a client we've acted for through the generations, so we've been acting for them for many, many years. And I would say in the last 15, 20 years or so, I've possibly done no more than 2 or 3 possession claims for that client, despite the number of properties and tenants they have. It's a remarkably low figure. I think we have to bear in mind still that the court is the last resort. And as I say, if you can agree something as an alternative to an eviction, then you should do that. I think the further point to note that's very important is a landlord's obligations are unchanged. A tenant is still entitled to a decent, warm and safe place to live. So a landlord has got to ensure that their property is well maintained, in good repair and free from hazards. And that has not changed and doesn't change even with the COVID restrictions in terms of maintaining the property, getting in there to maintain if you can. I've put up on the slide a website address. There's some good guidance there. It's a government website address, but good guidance for both tenants and landlords. But if you're in doubt or you need to deal with a problem, it's always worth getting expert advice. One of the problems with the longer notice periods is that if there's a problem with the notice, a defect in it, then you won't be able to run a claim in the court. It will get thrown out. So you may as well get it right straight away, because if you find out 9 months later, say 6 months after the notice and 3 months into the claim that it's defective and it gets thrown out, you're really going to regret that. Finally, just 2 points from me. Has there been a real impact on landlord and tenant work in the sort of COVID period, if I can call it that? The short answer is yes. And in fact, only yesterday I came across a statistic which was dealing with the number of possession actions issued by both the public and private sector in the period July to September last year. So July to September 2020, and compared with the same period in 2019, the number of possession action claims issued in the court was down 88%, 88%, which is a pretty staggering figure. Bear in mind that this legislation is currently enforced till the 28th of March. So the big question is, will it be extended? And the answer to that is, I don't know. Sadly, I don't have any inside track on that. But I have to say that if I was a betting man, my feeling would be that it probably will be extended, or elements will be extended, simply because currently, with the current lockdown that we have and the talk of that running till March and maybe even Easter and maybe even beyond, it's difficult to imagine that the government are going to release or change some of these restrictions on evicting tenants for landlords anytime soon. Thank you for listening. That's the end of my talk. I'm going to hand you back to Helen.
Thank you very much, Andrew. That was fascinating, really interesting. Now, I'm sure out there there will be some questions that you would like to ask Andrew. But what I'm going to suggest that we keep all our questions till the end, and can you please put them in chat, and then we'll deal with them after David and Yildiz. So we're now going on to the commercial sector, and we're going to hear from David Hacker, who's obviously, as you know, one of the partners and head of dispute resolution, which I think is such a fabulous title. David's going to talk to us about commercial property, rent arrears, landlord and tenant update. Over to you, David.
Thank you very much, Helen, and thanks everybody for joining me and my colleagues this afternoon. It goes without saying, but I'll say it anyway, that this last year has been a pretty tumultuous one for everyone, and I'm sure for all of us, those of us in business, probably the most unsettling and difficult year that we've ever experienced, and hopefully will ever experience. At the outset of the pandemic, I didn't really have an idea about how my own sort of practice area would be. I thought there was a chance, in fact, that the legal world would almost completely grind to a halt. In view of those sort of figures that Andrew's just given you about possession claims, you might think that's the case. In fact, for me, it hasn't been, and in some ways, my practice area has been far busier than I ever anticipated. So what have I been doing? Well, I have spent quite a bit of time this last year dealing with my landlord and tenant clients and seeking to help and guide them through their rights and obligations in these unprecedented times, with a view to helping both of them sort of coming out the other side with their businesses in as good a shape as they can be. So I thought I'd spend some time this afternoon just giving some guidance, whether you're a landlord or a tenant, or indeed neither, as to what the current legal position is with commercial leases, what your rights are, what you can do and what you can't. In a lot of ways, the commercial property area is actually quite a bit more straightforward than residential, for the reasons that I'll explain. Could I have next slide up, Mike, please? Sorry, previous slide. Jumped ahead a bit. Previous slide, Mike. Yeah, great, thank you. A client of mine sent me some sort of interesting statistics recently that probably reflect my own experience with different types of clients that I have. You can see from this slide that it was reported in December what land securities had collected in terms of the rent that were owed to them. You perhaps won't be surprised to hear that retail, leisure and hospitality have paid quite a low percentage of the rent that they are owed. And in view of the fact that most of them had, or many of them would have been closed for much of the year, that figure's perhaps not as low as we might have expected. Yeah, next slide, please, Mike. So what is the current situation in relation to rent arrears? In essence, when the pandemic hit, the government put the brake on actions that commercial landlords could take in the event of arrears accruing by their tenants. So currently, a landlord cannot forfeit, i.e. bring to an end the commercial lease. A landlord cannot exercise what's called commercial rent arrears recovery, but by taking possession of a commercial tenant's goods. A landlord cannot issue a winding up petition against the tenant's business for failure to pay rent, which often generally includes service charges, other than in certain limited circumstances. And those restrictions have been extended a number of times and are currently in place until the end of March. So that does not mean, however, that the landlord does not have the right to claim the rent or that the rent liability does not continue to accrue. It just means that the ability to recover the rent is very much limited. So what can the landlord do? Next slide, please, Mike. There's a number of things, in fact, that landlord can do. Firstly, if there's a rent deposit, landlord can draw down on that. There's nothing in the COVID regulations that prevent it, but it does mean potentially exhausting a rent deposit that might be there for other reasons. And whilst there's an obligation on a tenant to replenish that deposit, if they can't pay their rent, it's unlikely they'd be able to do that in the short term. If there is a guarantor of a lease, then a landlord could potentially call on the guarantor. And it's also possible to serve notice in certain circumstances on former tenants or guarantors of former tenants to meet rent liabilities. There is a 6 months time limit for that. I mean, it's something that I actually did for one of my clients last year. Perhaps unsurprisingly, the former tenant was rather surprised and less than pleased to hear from me, but it did actually help resolve the position for my client. It's possible also to serve notice on a subtenant, if there is one, for rent to be paid directly to you as the head landlord. Landlords can still take court action against their tenants by issuing effectively a monetary claim for the rent, but that does involve paying what could be quite a hefty court fee, and doesn't necessarily lead to the actual recovery of the money, but merely a judgment acknowledging that the rent is due. Alternatively, landlords can enter into payment agreements with their tenants whereby perhaps rent is waived or deferred, and I'll talk a little bit more about that in a minute. So those are the options really as things stand from the landlord side. What about if you're a tenant? Next slide, please, Mike. On the face of it, tenants are in a strong position as regards action that landlords can take at the moment. But my own experience over the past year is that tenants who are paying nothing are storing up problems for themselves, both now and in the future, and obviously causing problems in their relations with their landlords. As you can see from my slide, the best advice that I can give to a tenant, if they can't pay all or any of their rent, is to talk to their landlord. And if that fails, try again to talk to your landlord. Having any sort of dialogue with a landlord will inevitably help the situation, even if payment is not something that can take place immediately. Your landlord may not be happy to hear what you have to say, but in my experience, hearing something is better than hearing nothing. If you can pay something towards rent, even if it's very nominal, then pay it. It hopefully helps keep your landlord on side, and it does show some goodwill. And it acknowledges the fact that the money is due and that the tenant's doing their best to pay what they can. You may be aware, and I can send you a web link if you're interested, that the government published a code of practice last year about relationships between commercial landlords and tenants, advising them about how they should act. And much of what's in that code of practice is reflected in what I'm telling you today. So as a tenant, or indeed as a landlord, try and reach agreement if you can. Certainly document your efforts and essentially document any agreement that you reach. Next slide, please, Mike. So my experience over the past year in particular is landlords understand that tenants have difficulties paying their rent. They understand that tenants cannot potentially pay all of their rent. Most of the cases I've dealt with over the past year have involved landlords agreeing to rent deferrals, perhaps the rent being paid over the remaining term of a lease. A lot of tenants ask for rent waivers so that they don't necessarily have to pay the rent at all, come what may. In my experience, landlords have been very reluctant to agree to that, and to a certain extent, I can understand why. We do not necessarily know how long this situation is going to last, or indeed how badly affected a tenant's business might be. There's no major imperative on landlords to agree to waivers at the moment, because they can agree to them perhaps at any time at a later date. So landlords, I think, may be taking the view of let's see where things go and look at the tenant's business at some later point when hopefully the position is clearer than it is now. So all of these things are available to landlords and tenants. And as I say, again, in my experience, most tenant clients are paying something towards their rent. So that's really the position at the moment. As I say, it's a lot more straightforward in some ways than it is for residential landlord and tenant relationships. Whilst court action and other legal powers that landlords have are very much restricted, the necessity, and as I say, this is reflected in what Andrew says and what my colleague Yildiz will say, is dialogue between both sides. Particularly at this time, but I would say at any time. Again, in my experience, it's when things go very quiet and the landlord's hearing nothing, that's when particular problems arise. So I spent a lot of my time over the past year negotiating terms between landlords and tenants, and I'm hopeful that as a result of those efforts, that both sides can continue to have good relations. Something that will certainly be crucial when things start returning to some form of new normal, whenever that is and whatever that is. So that's what can be done and what can't be done, and what I suggest is done. I'm going to hand over now to my colleague Yildiz, who will speak in a little bit more detail about the actual mechanics of that and what she's been doing over the last year, because Yildiz deals with the more non-contentious side of things. So many thanks for your time, and I'll be happy to answer any questions at the end. Thank you.
Thank you, David. And I think we have, I'm going to hand over to Yildiz. And as I said earlier, Yildiz sits on our board. And Yildiz is in charge, he's the head of real estate, and her area is commercial property, commercial property, sorry, I can't read my writing now, lease variations and termination. So over to you, Yildiz.
Okay, thank you, Helen. And thank you for joining us today. So people come and talk to me first and hopefully avoid having to talk to David. I'm going to echo what everyone has said so far. Collaboration will be the key to surviving this economic shock. Commercial tenants initially led the way after the first lockdown, requesting rent to be waived, deferred, reduced. 4 quarter days later, and as a result of this, I've seen the landlord and tenant relationship shift towards partnership, with both parties focusing on the success of the tenant's business. Most commercial landlords now understand the need to work with their tenants and to agree changes to the lease which are mutually beneficial. Speaking to each other about the challenges ahead should be the first port of call. The types of changes I've seen being made to the leases are rent concessions, which have been previously mentioned, alternative rent structures, and more recently, extensive restructuring of the original lease terms. There are 2 ways of recording those changes. One is by way of a side letter, which is for a more temporary and personal arrangement. The other is by way of a deed of variation, which is a more permanent, or is a permanent variation, which binds anybody that buys the landlord's property or the tenant's leasehold interest. Next slide, please, Mike. Firstly, let's talk about rent concessions. So as a landlord, you've been approached by your tenant asking for help as they're unable to pay their rent, and you're prepared to offer some assistance to them, but where do you go from here? And what else do you need to think about? First of all, is the tenant's business genuinely in difficulty? There have been both winners and losers during this pandemic. Not all businesses have been affected in the same way. So it's important to ascertain if the tenant can actually carry on paying the rent. If they can't pay the rent, are you agreeing to waive that rent altogether, or is it just being deferred? If the rent is being deferred, when will it be paid? The best approach is to agree a timetable for repayment now. Nobody knows when the situation will change, and it seems likely that some businesses will open sooner than others, so the landlord will want repayment to be triggered when the tenant is able to trade again, not simply when all restrictions are lifted. Does the concession apply only to quarterly rent, or does it include the service charge and insurance? Even where a property is closed, the landlord still has to insure the property and provide basic services, so it could suffer additional loss if the tenant doesn't contribute to these. And what about interest? Will this automatically be charged on the back payments, or just if the tenant has done something to trigger early repayment, for example, if they breach the lease terms or a side letter? You may also want to specify automatic events for termination of the arrangement, such as the insolvency of the tenant, the breach of the lease terms or the side letter, or if the tenant wants to assign or underlet the property. If there is a rent review that will arise during the period of the arrangement, what's the agreed effect on this? From a landlord's point of view, you wouldn't want a negative impact on the rent review resulting from the rent concession. Are there any confidentiality issues? If you have more than one tenant, then you might not want the agreement publicised to other tenants and set a trend for others to make the same request. This should be covered in any agreement reached. If you have finance secured against the property, they will probably need the lender's consent to agree any rent concessions. Lenders are likely to take a pragmatic view, but it's important to talk to them. Any guarantor of the tenant's obligations in the lease should also be joined in so that they're also bound by the terms of the arrangement. Finally, it's also advisable to check with the accountant that there are no adverse tax implications that might result which might result from what you've agreed. So as you can see, a simple agreement in principle is never that simple, and care should be taken that an act of cooperation does not backfire on the landlord. The other types of changes that I've seen are alternative rent structures. Traditionally, commercial tenants have paid rent in advance in 4 quarterly instalments with rent reviews every 3 to 5 years. COVID-19 has placed increasing financial pressure on tenants' cash flow, so it's in everyone's interest to structure the rent in a way that reduces day-to-day pressure on the tenant's business where needed. The simplest alternative is monthly rent payments, but the landlord and tenant must be both clear about whether the rent will be paid monthly throughout the whole of the lease or if it's just a temporary concession. The other alternative is turnover rent, which is most relevant to retail tenants. Retail tenants are increasingly asking for their rent to be based on their turnover. Typically, there'll be a fixed minimum rent with an additional payment calculated as an agreed proportion of the tenant's turnover, so they'll pay less in difficult times. This arrangement means the landlord takes on some of the risk of a retail business in a challenging trading environment. Turnover rent provisions in leases are complex and must be drafted carefully. They can only work if the tenant is able to produce timely and accurate trading figures and share them with the landlord. One of the biggest issues is working out what goes in the turnover calculation. This is particularly difficult where business operates online as well as from a physical premises. The landlord could argue for a cut of the online sales on the basis they may be generated by visits to the physical shop, which is effectively operating as a showroom. This is becoming more and more commonplace. The other types of changes I've seen to leases are landlords agreeing extended rent-free periods in return for tenants postponing their break dates, and also the rent being reduced in return for the part of the premises being surrendered back to the landlord, such as the upper parts of a building, so the landlord can redevelop them. Next slide, please. However, there'll be circumstances where the changes to the lease terms may not be enough. If the tenant's business is still struggling, it might be tempting for the tenant to simply hand back the keys and walk away from the lease, especially if its lease is not due to expire anytime soon. However, ending its obligations early under a lease is not that simple. The options that may be available are exercising a break clause, surrendering a lease, or an assignment or underletting. So firstly, break clauses. The first thing you need to check is whether the lease had the break clause, which will give the tenant a right to end the lease early. Timing is critical, as most breaks can only be exercised on specific dates during the lease. The tenant will have to serve written notice on the landlord, and the lease will set out how many months ahead of the break date this must be done. There are lots of possible traps here, especially if the lease sets out detailed requirements for how and where the notice must be served. It's always safest to get a solicitor to check the lease and serve the notice. Once the notice has been served, the tenant will need to get ready to move out by the break date. Most break clauses have conditions attached, and if the tenant doesn't satisfy them, then they'll be stuck with the lease. Typical conditions include paying any rent and other money due to the landlord at the break date, leaving the property in a proper state of repair, removing all stock and equipment, and possibly undoing any alterations made during the lease. The tenant should be careful not to leave anything in the property, as this could be treated as a failure to vacate. Again, it's really worthwhile getting advice from a solicitor, because even a minor oversight in relation to break conditions can make the difference between ending the lease and remaining on the hook. If the tenant doesn't have a right to break, the tenant could approach the landlord to negotiate ending the lease early by surrendering it. The landlord is under no obligation to agree, as an empty premises is not an attractive proposition. However, the tenant may find that the landlord has another possible tenant lined up, or they're planning a redevelopment or change of use, so it may suit the landlord to end that lease early. If the tenant surrenders the lease, they'll be released from any future obligations, but the tenant is still liable for anything that was required to be paid or due while where the lease was in place. This means that when negotiating a surrender, the tenant should expect to reach some sort of agreement about the outstanding payments, the cost of any repairs needed to the property, and may even have to pay an additional premium to compensate the landlord for loss of rental income. Once the terms are agreed in principle, the surrender should be recorded by way of a deed of surrender, especially if the lease is registered. Finally, if the tenant doesn't have a break clause and cannot agree a surrender, the other option is to look for someone to take on the premises, either by taking on the lease itself or taking an underlease. Before the tenant starts looking, they should check with the solicitor whether or not the lease allows an assignment or underletting, as these could be restricted. The tenant usually will need the landlord's consent, and the landlord will need to be reasonable, deciding whether to accept any new tenant under tenant. But they can also impose specific requirements, such as a rent deposit deed, depending on the financial standing of the tenant, and also could require the outgoing tenant to guarantee the incoming tenant under an authorised guarantee agreement. Next slide, please. So I hope I've demonstrated that there are various options open to landlords and tenants. Commercial landlord tenants should be proactively communicating with each other and, where possible, coordinating efforts to mitigate against the impacts of COVID-19. This is not a time for either landlords or tenants to try and gain advantage over one another when they're both subject to adverse circumstances in a way that no one could ever anticipated. Commercial landlords and tenants who take the right steps now with the right advice will have the best chance of preserving their financial position for the future. So thank you for joining us today, and I hope you found this helpful. And I think we now go back to you, Helen, for any questions.
Thank you very much, Yildiz. I found this absolutely fascinating. Now, if you do have any questions, can you please put them in chat now? I've just got a couple here, and I think, should we remain on the commercial sector? One of the questions I have for Yildiz is, what do you think will happen when the current restrictions are raised?
Okay, I think that might be a better one. Yeah, I think that's a better one for you to answer, David, because of all the court proceedings.
Yeah. I mean, it's a really interesting question. I think which I think about a lot. I mean, the trouble is there's a huge amount of rent charges that are going to have built up over the past year. I don't think the government can just release the restrictions and allow effectively back to where we were before March last year. So I think there's going to be they're going to have to put in some sort of provisions when they do eventually lift the restrictions for landlords, not just to be able to immediately go and forfeit leases where their rent arrears have accrued over the last year or so. So I think there's going to be some sort of tiered approach, to use modern parlance, to when they raise it. So yeah, I mean, watch this space, but I think it's I think they're going to have to be very think about this very carefully. Otherwise, it's going to be really, really difficult out there.
Right. Thank you, David. Another question I've got here is, and this is actually, I think it's quite a really interesting one. And what would happen if a commercial tenant literally just stops paying the rent? What happens?
Well, again, that's for me, really. I mean, at the moment, it depends. I mean, as I sort of said in my talk, if there's a guarantor, there might be somebody you can go against, a guarantor or a former tenant. But if a tenant just stops paying their rent, and a lot of them have at the moment, the options for commercial landlords are very limited. I mean, Andrew might want to say something about the residential. I imagine which is fairly sort of similar.
Thank you very much for that, David. Well, let's go on to. Shall we go back to Andrew and ask a residential?
Yeah.
Thing. This is a good one, I think. And can you give us any tips on how to avoid, having any residential tenants who fall into arrears, breach their tenancy agreement? Any tips to make sure they don't get there?
Well, I think, sometimes there's a big case there. The horse is already bolted, as it were. But I think it all starts really at the beginning when you first take on a tenant, and it amazes me how often landlords do not do thorough checks on a tenant, or agents don't do thorough checks on a tenant before they take them on as a tenant. Generalizations, but most tenants will come to you probably having rented somewhere else before, unless they've been unfortunate and evicted because of mortgage arrears or had something like that. So one basic thing to do is not just try and contact, but ring up the previous landlord and see if they'll give a reference and if they'll give you a warning. So thorough background checks are really important. If you get a reference from an employer about the tenant, I'd actually ring up that employer and just double check it's genuine. I mean, I've dealt with many cases over the years where the references have just turned out to be wrong, or rather not wrong, basically fraudulent. I've seen cases where people have done an ID check, and when they show me the copy of the passport they took at the time, the passport is a couple of years out of date. So, not ideal. And I think as a again, a general point, but this is based on my experience of doing this for many, many years. There are generally really only good tenants or okay tenants and bad tenants. There are far fewer bad tenants than good, I hasten to add, although bearing my work, I've probably got a bit of a jaundiced view, but people only come to me when they've got a real problem. But if you can weed out the bad tenants and spot them, then, and avoid ever taking them on, then you'll be fine. I know many, many landlords who have let property many, many times without any real serious issues with a tenant. And, to that extent, the other thing I'd say, which I did mention in my talk, is as soon as you can see there's a problem, or the rent doesn't hit the rent account on time, you need to be ringing the client, the tenant, speaking to the tenant, find out what the issue is, because often you can, prevention is better than cure. And you don't want to be one of those people who sometimes come and see me and I say, well, what are the arrears? And they give me a fairly eye-watering figure, and you think, gosh, this must be a fantastic property. But in fact, it turns out that there's 8 or 9 months rent arrears there, and they've just done nothing about it.
Yeah, fascinating. Now, this is going to be the last opportunity. Oh, we have a question from Luke. Luke, would you like to give your question yourself?
Yeah, it probably help to decipher it, wouldn't it? I just wondered whether the current changes that are apparently temporary and sort of coronavirus specific, whether you think, I mean, I'm not asking you to write this down so that I can see you later on, but whether you think that those may well sort of create long-term changes which make it either more or less appealing for people wanting to become professional landlords or professional sort of landlords for a job, i.e. the don't evict us now side of the law, is that being weighted more heavily now towards the side of the tenant than the landlords, and will that be a long-term thing?
I suppose that's kind of more for me. I assume you could have think, you mentioned in the chat residential rather than commercial. Well, I think I've got to say for the moment this is temporary, because when the Coronavirus Act came into force last year, it said very clearly that it's only enforced until the 28th of March, I think it is this year. And it was brought in specifically as a reaction to the coronavirus and primarily to protect tenants. I mean, the government said that no tenant will be evicted for at least 3 months. They don't necessarily have to pay their rent for 3 months, and landlords can't start possession proceedings for at least 3 months. I mean, actually, most of that wasn't actually enacted, but the sort of gist of it is there and the spirit of it is there. So on the face of it, yes, it's temporary. I think there are changes afoot in the sense that there's been a lot of talk of doing away with Section 21, which is the default, usually the default notice to serve on a tenant when a landlord just wants a property back, and that was being discussed well before coronavirus. And there is, I think there is a bill that's to be debated in Parliament about that, and there's been consultation about that. So there may be a bit of a leaning towards tenants. I mean, people often have said to me over the years, "Oh, it's all this is far too pro-tenant." But I've often said to landlords, "No, if you get everything right, you can always get your property back." There may be a leaning towards the tenant because of that. The only thing I can tell you, I was on a Zoom call with the Sevenoaks MP a couple of months ago, and I asked a similar question actually, whether the notice periods would stay as long as they are and whether that would change anytime soon, and particularly into this year. And she did say that she'd supported the current act and the current provisions, I think as most MPs had, but that she would not be keen on seeing them put in permanently. So, for example, to give Section 21 notices as an example, she certainly said very clearly on that call that she would not vote for them remaining at 6 months, and she would like to see them come back to 2 months. So that was an indication that maybe over time this will be reversed. But as you say, I can't really say. I don't know, but that would be my guess. But as I said at the end of my talk, my real concern would be, well, not real concern, but a concern at the moment is that the current provisions will be extended beyond the end of March, because it just looks that way at the moment, because what's been said about the general lockdowns being extended beyond half term in February and beyond there. I don't know. Hopefully that's helpful, Luke. I'm not sure whether it is or isn't.
It is, yeah, no, thank you.
Thank you. Right, I don't know if we have any more burning questions.
I think there's another one in the chat from Barbara, but for my colleagues, I think, rather than necessarily for me, I think.
Okay. Barbara, would you like to ask a question?
Yes, hello. My question is just, and it may be a simple and straightforward one, but I tend to work with more and more conversions from commercial to residential. What are in principle the options of a landlord to end a lease agreement if you wanted to convert the property to, say, residential or office?
Okay.
Is it just down to the notice period, or are there any other options under the current circumstances?
So David, I'll take that one. So hi Barbara. So it's not that simple. Basically, you'd have to look at the lease first to see if this is a lease that's got is outside the 1954 Act or within it, to establish whether the tenant has security of tenure or not. And it also depends how long that lease has got left to run. So if the lease is going to run out soon and the tenant doesn't have a right to renew, it's excluded, then basically the landlord just needs to wait for that lease to expire, because then the tenant will just need to move out at the end of it. However, if it does have security of tenure, if it has got a right to remain and a right to a new lease, so up to 12 months before the lease expires, the landlord may need to serve what is called a Section 25 notice, basically opposing a renewal on the ground of redevelopment, and compensation will be payable to the tenant at the rateable value, or if it's been there for more than 14 years, at twice the rateable value. However, if the lease has got a load of time to run and you want to end that lease early, then it's the reverse of what I talked about, is that you look to see if the landlord has a break clause in the lease, which can be exercised at all. And if not, then they may need to approach the tenant to see if they can agree a surrender. And they, in that circumstance, they might have to be paying the tenant something to go early. But if the tenant is in arrears and is really failing as a business, then actually they may welcome that surrender. So yeah, it's kind of taking it one step at a time as to what type of lease it is.
All right, thank you.
Thank you. Right, I don't think we have any more questions. And I would like to thank the partners of Thackeray Williams for, I found this an absolutely fascinating event. We're going to, in a little while, you will see this, we'll put this on the Chamber's new website, or revamped website. And I can let you know that the second South East London Chamber Property Group event will be taking place on Tuesday, the 27th of April, 2 o'clock again. I would like to thank Thackeray Williams, and also to thank Luke Bryce for being our sponsor. And I'm so pleased that you're such an expert on Croydon, Luke, because the Chamber will be back to ask you all sorts of questions. And we do hope to see you and Blue Light Group as members of the Chamber in the future.
Will do.
Now, and a big thank you to Team Think Events, for you put such a brilliant event on. Thank you.